Arbitration, Mayor Small.
Okay, may I have just a little bit of time, there's quite a lot to respond to there.
Sure.
Thank you. Just so we don't lose the train of thought. My clients found out about the floodplain permit as it was inserted in a letter that Council EQT wrote to West Virginia Department of Environmental Protection. The letter itself with attachments was about an inch thick. The mailing date was the 16th. It was going from West Virginia to California. Trust me, it takes a while. Add on the time of actually getting through it all. And the 30 days didn't expire when she found out, or when my clients found out, until after the permit was rescinded or revoked. So maybe in hindsight, they could have brought an appeal just to preserve the right to appeal about a permit that no longer was a problem. I'm not sure what they were supposed to do in that situation. There was no permit at that point. If I remember how it all went down correctly. I could be wrong, but I seem to remember that it was taken care of. I mean, it was not the issue that it was hanging over their head. I wasn't the counsel at the time. It was previous counsel. I'm not just saying that because that's the easy excuse. There was a reason. Whether it was the statute of limitations of state as a litigation, I don't know. But as to the constitutionality, Tufts did maintain that. It's an affirmative defense in their answer. And our position is as long as it's litigation, then it still hasn't been touched. And, you know, there's a lot of thoughts that actually we could have brought it against the county, but what was the point in pressure? You know, no, we're not going to go after the county for money. An individual made a mistake. A county made a mistake in not letting this guy think he was the floodplain administrator. He made a mistake by not doing a review. Going back to Mr. Sneed, Mr. Evans, he said, I told him they had to get a hold of him, Sneed, and find out what they had to do because I didn't know what they had to do. That's what I'm talking about with justice and public policy. You have the guy who is not supposed to be the floodplain administrator, the gatekeeper keeping from having stuff built in their floodplains and flooding them, and he doesn't know what to do. Well, the correct individual, the director of emergency services, is trained in this aspect. That's why it's there. And yes, he was appointed in January 2010, and that was fine under the old ordinance. Under the old ordinance, the president of the commission could appoint somebody to be the floodplain manager. Well, September 2011, they enacted a new ordinance. And now the president doesn't have that power anymore. So this office that was created, the president had the power to do, ceased to exist. And it was Jared Evans who made the motion to enact the ordinance. And as to poor EQT being at its wit's end on what to find out and relying on just calling the clerk, if I was going to spend $30 million to build a project, I'm going to do everything possible to make sure that it's correct, that I'm talking to the right person. You can look at the meeting minutes. If the guy's not answering the phone, maybe that's a sign that something's not right. You can talk to Kevin Sneed. And as to the county ratifying it, well, that goes to something interesting. EQT at no point, they just assume that the floodplain manager is an officer. They don't show why he is an officer. This is some complicated stuff. I came across a case where superintendent of schools were officers in terms of de facto. So just jump ahead and assume the floodplain manager is an office, I think is inappropriate and doesn't fully analyze the de facto officer. But going back to the county. So at some point, when this all happened, they went back and looked at their ordinance. And on May 1st, in the county meeting minutes, and I believe it's in my motion for summary judgment, they acknowledged that the Director of Office of Emergency Services has to be the floodplain administrator. Kevin Sneed emails them shortly after and says, hey, y'all need to amend your ordinance. Here's how you do it. Now, from what I understand, the reason they haven't amended it is because the prosecuting attorney, the county prosecutor, is very busy. And this would take a significant amount of time to go through and read it. It is a flawed ordinance. You go into the notice then. You have somebody affecting adjacent property owners. And people keep saying thinking the Huffs or the surface owners. They're the adjacent property owners to this project too. Two-thirds of the project, I mean, it's on either side of the property, and then one piece is on their property. And they never got notice. And I love the fact how EQT is bemoaning the fact their due process rights are trampled on, and you shouldn't strictly construe the Open Government Proceedings Act, even though it says citizen. But when it comes to somebody else's due process rights, oh yeah, no big deal. They waive their appeal. They have no due process rights. I mean, the rules apply to EQT in a way that they don't apply to everybody else. EQT can skirt the rules, but if anybody else makes the slightest mistake, EQT is going to jump on them. And when I hear this thing about EQT complying with the ordinance all the way, I mean, I'm looking right now at an April 19th email between EQT, several employees, where the representative for EQT is getting an email from one of the permitting people, Wayne, in its current format presentation, the submittal does not meet the requirements set forth in the ordinance. I mean, EQT right here is saying they didn't comply with the ordinance, and this is almost 6 months after well, 5 months after they applied for it. I mean, if that is an unplanned or jumping ahead, I'm not quite sure what is. If you know that you did not comply, and then you come here and saying, I complied, and everybody else, they messed up, so give me my permit back.
You know, with all respect, Mr. Richard, we will be here all day, arguing these things. We submit a motion to address that. So I was asking Mr. Richard to move along. I just had a question.
I have one more than the whole May 1st thing, you have to understand, the LDS director resigned on May 1st. The same day that the county realized that their ordinance said that they didn't have anybody else to give it. Not only did they amend it because their prosecuting attorney, they didn't have an LDS director until alone to do. Going back to the constitutionality, again, Harrison County, Illinois, speaks for itself. The due process, you have no right to terminate the order because it violates the order. Going back to maybe the Commerce Clause, I think. Commerce Clause, since the citizens-only provision doesn't specifically say it applies to commerce, you have to go to the dormant Commerce Clause. It's not. It's not a law that implicates economic protectionist principles. It's a law, the purpose of which is not to protect in-state business. It's just to hold governmental officials accountable to the people who vote for them, the people they represent. It's not saying it's keeping EQT from doing business. It's just there to prevent secrecy in government for the actual citizen. And, strict construction of legislatures, it's pretty clear. There's no wiggle room. The circuit court in the county where the public agency rarely meets has jurisdiction to enforce this article upon civil action commenced by any citizen of the state within 120 days. So, I mean, it's gone for everybody else already. The deadline passed 3 months ago. But it's very clear. And he says, and Mr. Hastings says that it was a Virginia court. It was the Fourth Circuit Court that upheld a Virginia Freedom of Information Act, citizens-only access provision. And that wasn't the only case that upheld that. But that was the most authoritative in terms of its standing, I guess. Trying to check if there's anything else that we can throw out there. We had no problem getting a copy of the old ordinance and the ordinance against it. And we're not a multi-billion dollar corporation with a legal department and an outside permitting firm.
All right, I think I've got a pretty good understanding.
Thank you.
Do you want to respond?
I'm going to be very, very fast on if you want to come after me.
That's right.
Let me be clear on a couple things, Ron. And again, we need to see the issues. How much money we have and who we have in the permitting process has nothing to do with this. The issue is this floodplain permit. That's what we're here for today. Whether the injunction authority of this court is appropriate. And regarding Jerry Evans, let's be clear. Shirley Williams, President of the County Commission, appointed Jerry Evans. Jerry Evans acted. The County Commission, after the enactment of the ordinance, accepted his resignation. If he wasn't the floodplain manager, they don't need to accept his resignation. It's clear. I mean, it's a question of fact at a minimum, Your Honor. And so it precludes summary judgment at this point in time, and we just need to move forward with everything else we have here today. Regarding the Open Government Proceedings Act itself, again, I'm not going to belabor every point and every note in our brief. You have these briefs in front of you because of the responses filed. But even if you think we're wrong on everything, substitution of a citizen in the city of EQT for this claim only is appropriate, and there's no prejudice to anyone. I mean, Mr. Richardson and his clients are quickly to point out in prior proceedings in this case, even in this courtroom before the County Commission, that we all need notice. So I think if we want to talk about policy and justice, that's the clearest one in the case. Now, briefly, I don't think you really responded to the motion that we're arguing at this point, which is a motion to limit on constitutionality. And he wants to talk about the date of March 16th. The DEP sent Joy Huff a letter February 10th. Give her 30 days, March 10th. We got notification of something March 6th. We sent notification some point in time in March or whatever it was. Your Honor, the bottom line is they sat on the right. So that's a very limited motion limiting. The purpose of the motion limiting is to limit stuff that's irrelevant. And we're willing to reserve everything else until the point in time that comes up in testimony today. And we just want to move forward with the rest of the motions to the extent the court needed, obviously, Mr. Tennyson.
Your Honor, with respect to the first motion, intervener's motion for summary judgment on the issue of the validity of the permit as issued by Jerry Evans, I want the court to understand and the record to be clear that as representative of the Dodge County Commission and the good public servants that these commissioners are and attempted to be, that I will not argue contrary to the actions of these individuals in the commission itself, so I stand silent with respect to that motion. That motion kind of, an argument morphed into many other issues here, and I feel compelled at this stage, just so I know you're taking notes, with respect to the Open Governmental Proceedings Act, I think that the evidence today will clearly show that on April 17th, there was citizens that came to that meeting which were not on the agenda and did voice concerns to the county commission at that point. And the county commission did, without it being on the agenda, did make a decision to seek a rescission by Jerry Evans, the floodplain manager, of the permit that had been granted by Jerry Evans. The argument that we're going to bring forward, Your Honor, is under the floodplain ordinance itself, 7.7A2, it was unnecessary for anything to go before the county commission. The floodplain manager has a unilateral right to issue a stop order to cause the permit holder to stop all work in progress on a planned development within the floodplain. The ordinance does not require any notice to anyone. It can be an absolute unilateral act by one human being, that being the floodplain manager, to issue a stop order. Okay. Now, did Mr. Evans use the word stop order in his letter of April 18, 2012? He did not. He used rescission. It's just an improper use of the word. The practical effect is that the floodplain manager wanted to stop this progress so that this can be further looked at based upon the evidence that was presented, which were the photographs that the Huffs and the Fosters brought forward that showed that there was massive flooding in the zone where EQT wanted to put the drill pad. So, with having said that, I'll sit down. If you have any questions, I'd be glad to.
Before you sit down, I do have a question.
Yeah.
The people that came before the county commission on, what date did you say that was?
April 17 of 2012.
April 17th. How did they know to do that?
I don't know.
They weren't given any notice.
They were not given notice by the agenda that was published correctly for the April 17, 2012 meeting.
Were they given any other kind of notice of the proceeding or the permit process or any of those issues?
Not to my knowledge, Your Honor.
So they must have just kind of found out about it and decided maybe they wanted to come and say something to the commission.
Yes, which in most commissions around the state of West Virginia, I know in Ohio County, where I'm a part-time county solicitor, there's an open call. At the end of the meeting, does anyone in the public wish to address the county commission?
Sure, what county is that?
Ohio County.
Ohio.
And various people get up from time to time and voice concerns, and the commission hears their concerns and may take action later on that issue. In this particular instance, unfortunately, what occurred was there was a presentation of concern about this permit that was issued by the Huffs and the Fosters, and the county commission did in fact move forward, unfortunately, to take a vote on ordering the floodplain manager to rescind the permit. But I contend that was an unnecessary act because the floodplain manager had unilateral authority to do that without any presentation. So to the extent that there was not agenda notice to EQT, it really is an immaterial factor because the floodplain manager could have done it and should have done it without any consideration of any presentation to the commission or having the commission vote on whether the permit should be rescinded or not. He has absolute unilateral authority to issue a stop order, which is essentially, as I said, in practicality what occurred in this instance.
Well, let me ask you this. Do you think that's and I don't mean to put you on the spot here, I guess, but do you think, maybe I shouldn't ask you if that's a good way to proceed, but do you think that's a legally proper way to proceed, just to have this action and leave everything to fate in terms of whether somebody can find out about something, whether that's EQT, whether that's the Huffs, whether that's the Fosters, and be able to just put it together and come in and make a comment on it, even though there's no requirement that be done, and the floodplain administrator, whoever he is or whoever's acting in that capacity, may have the authority to listen to what they say and take further action. Do you think that's a good way to proceed to afford everybody their rights, I guess a legally proper way to proceed to afford everybody their due process rights under an ordinance?
I do because the stop order simply stops the progress of the development in the floodplain. And in this instance, nothing had occurred. You know, all that EQT did was do their studies, do their mapping on the surveying of the land, and submit it for purposes of having the permit issued. The testimony you're going to hear today is from the date that the permit was issued to April 17th. There was nothing else done. There were no contracts let, there was no dirt moved, there was no drill holes drilled, there was no fracking that occurred, etc. So the essential rescission or stopping of the process does afford EQT an opportunity of due process because on May 22 of 2012, there was an open public meeting, which EQT got notice of, and they had a right to come forward and present evidence at that time, and they chose not to do that. So the stop order is just a timeout. It's literally a timeout in process, and it needs to be done on an emergent basis, and I think that's why the floodplain manager has unilateral right to do it without notice and without any due concern of taking it to the commission or not. It's a stop, it stops the progress, and then The parties have an opportunity to bring forward evidence to the floodplain manager, or in this case, the floodplain appeals board, to ultimately decide the issue as to whether or not the permit was valid.
What was the legal basis for that public hearing as found in the ordinance, or as determined by the ordinance?
Which public hearing, Your Honor?
The one you just referred to.
May 22.
EQT had the right to come, and they, I believe, there was a position of EQT that it was an improperly convened public meeting, and they opted not to participate. Is that the right meeting?
Yeah, that is.
Well, Your Honor, we didn't object and stay, just, we were there. We lodged an objection and just sat through the hearing.
Okay, all right.
Yes, Your Honor, the process under the ordinance is that appeals can be filed based upon the stop order being issued. Here it was called a decision, but it essentially stopped and had a timeout on the progress of the development. EQT, through their attorney, Mr. Hendrickson, sent a letter to the county commission objecting to the process of the rescission of the permit, which ultimately the county commission took as an appeal, that they were in fact appealing the permit rescission. And while it was, again, technically not properly noticed in the sense that there was a letter that went out that stated that EQT could present evidence to the floodplain manager, but in that particular situation, Mr. Evans had already resigned, Mr. Wellings had just recently been appointed, and at that point, the county commission took that letter from Mr. Hendrickson as a request of appeal of the decision to rescind the permit. And at the May 22 hearing, the Floodplain Appeals Board clearly stated that we're sitting here as the appeals board based upon the appeal that was lodged by EQT, and we're going to take evidence. Everyone had an opportunity. EQT stood up and objected to the process, didn't present any evidence. So they had a due process a right to be heard at that point on the whole issue, and they chose not to do so. And I mean, as far as due process generally, Mr. Hastings said that this is all about due process. Well, the due process, you have to even take even a level further as to whether all these little mistakes that were made were cured by the process that Your Honor allowed by agreement of the parties, and that was to send it back to the Floodplain Appeals Board and open this back up again where everyone could be heard. Any party could submit further evidence to the Floodplain Appeals Board, and ultimately the Floodplain Appeals Board did in fact then rule on the issue. So when you look at due process, they've had more than due process. They've now had an opportunity on 2 occasions to submit evidence to the Floodplain Appeals Board for the contest of the rescission or the stop of the progress of the work based upon the permit that was granted.
Thank you, Mr. Kennedy.
Your Honor, I have to clear up like 3
Just a
seconds.
minute. There's supposed to be more evidence matter than Mr. Henderson.
No,
I want to clear it up.
First of all, it wasn't a stop work order, it was a rescission. There's a huge difference between the two, and I know you recognize that. Second of all, these folks show up at a county commission meeting, and you can look at their agenda if you'd like to see a copy of that for that day. There's no open call. And they raised concerns to the county commission about this drilling that might go on. And lo and behold, Gary Evans is directed by a vote of the county commission, it's not noticed, to send us a letter rescinding, not stop work, rescinding our permit. Over, done. Okay, that's the first point. Second point, the May meeting wasn't a properly constituted meeting because number one, the floodplain coordinator wasn't there to resign. And number two, it wasn't properly noticed. And number three, as you go on through this process, Your Honor, Dan Wellings was appointed by the commission. Well, Dan Wellings doesn't meet the definition of the ordinance. He's not the OES director. So Dan Wellings wasn't properly appointed either. Now, I think even today, Dan Wellings is still acting as the floodplain coordinator for this county, even though he isn't the duly authorized person under the statute for the ordinance to act in that capacity. So what you have, Your Honor, it's not just a little slip here and a little slip there. What you have is you have the very essence of why you have the Open Meetings Act. I'm the chairman of the Higher Education Policy Commission. Everything we do has to be published ahead of time because we give everybody an opportunity to come and voice their concerns. We can't take up anything unless we're vote, unless we let the public know what's going to happen. And there's a very good reason for that, because we want to make sure as public policy that everybody that has an interest, whether you're a citizen, whether you're not a citizen, everybody that has an interest in what's going to be taken up on the agenda has a right to come and voice concern. And in the May meeting, we didn't want to jeopardize our due process rights by participating in what we thought was an ill-constituted meeting of the county commission or the floodplain appeals board. There was no appeal at the time. We already lodged our objection, saying, look, you have no right to rescind our permit to begin with, because you violated the process. We still maintain that in May. And we provided information before that, Your Honor, and the evidence is going to be that despite the fact that we gave them our study again, because they said they lost it or didn't get it the first time, I don't know which. Despite the fact that the state FEMA coordinator took it, sent it to FEMA, FEMA blessed it, the state coordinator blessed it, and told the county commission, it's good, reissued the permit, they still didn't do it. And so it's compounded due process error, one after the other, after the other, after the other. And that's why we're here.
And Mr. Henderson, what organization is it that you're counsel for?
I'm the chairman of the Higher Education Policy Commission.
Higher Education Policy. And what they do is a matter of public notice
All of them.
of the proceedings.
Yes, sir.
I guess the problem I have with that is this. How can a permit properly issued that is an issue or involves matters of public interest in general and property owners' interest specifically without any type of public notice generally to the public or specific notice to individuals who may have an interest in the outcome of the proceedings and have no opportunity to participate in that or otherwise exercise any position that they might desire to advance prior to the issuance of that permit, because they're the same position. You know, here we are, you're asking me to say this permit's good when there were none of these notice requirements met in general to the public or specifically with regard to potentially interested individuals, and say that this permit ought to be good.
I understand your concern, Your Honor, but it's a little different situation here. Let me tell you why.
All right.
The ordinance as written is what we have to comply with. If there isn't a notice requirement in the ordinance, that's not up for us to make that determination. That's up to the county commission or the citizens of this county to come back and change that. What we did, Your Honor, was to comply with the ordinance as written. Whether or not it required notice to the Huffs or the Fosters, that's not our issue. And so we complied with the ordinance as written, Your Honor. If it was flawed, we
I
did
understand
that.
your position.
Okay?
All right. Thank you, Mr. Henderson.
Your Honor.
All right, Mr. Richardson.
Thank you, Your Honor. There's two things that I think the attorney have been mischaracterized. That I don't want the court looking different on my clients because of the February third-party notice that was referenced. It doesn't mention the permit. It just says that the floodplain manager has been consulted. In fact, and this is West Virginia DEP saying this to the Hubs. In fact, at one point, West Virginia DEP lied to the Hubs and told them that Evans had been out there and seen the place. A month later, Evans is out at the farm campaigning for re-election. The first thing I was not was this person on the damage road. Second, the reason the April 17th open-ended meeting thing happened the way it did, Kevin Steed told Troy Huff and Foster to go there, take the letter they had written Mr. Steed explaining the situation, and take the photo. I just don't want anybody to think there's something nefarious going on. Construction is the guy who's in charge of implementing the floodplain ordinances. And I keep hearing this EQT compliant, EQT right here in this April 19th. They did not include the letter that you attached to your floodplain study, so it'll make sense to a non-engineer. It's required. You have to do it. And the purpose is so that the person who's reviewing it will know what they're looking at. These things are about 300 pages, and it's just calculations. They're basically unreadable unless you are a hydrologist or you have experience with hydro engineering. And they didn't comply with the ordinance. They didn't get the thing in. Give the floodplain manager the ability to understand what he's looking at in terms of the engineering aspect. So, I mean, really, there's issues on almost everybody's side. But when it comes to the permit, you know, except for my house, because they didn't get any notice whatsoever. And I like how Mr. Hendrickson says that we're dealing with the ordinance that we have when it comes to notice, but please change the open government procedure. It just goes back to the rules of the EQT and our rules. Thank you.
All right. Yes, sir.
Can I just clarify, is the board presently entertaining EQT's motion in limine to exclude argument pertaining to the constitutionality of the floodplain ordinance? Or did I miss here? Because we've gotten off a lot. I think it's still a good discussion, but I'm a little.
Well, I think probably they got into that a little bit, but primarily my concern and interest in that was to the extent that that is raised as a grounds in the intervener Huff's motion for summary judgment. So, but you're correct, it has been argued to some extent. If you'd like to address that, you may reply.
Okay, I hope I'm not jumping the gun, but I mean, just stated succinctly, I mean, as a matter of fundamental fairness, if EQT is going to be heard to argue unconstitutionality of the Open Governmental Proceedings Act, which is at best just tangentially involved in this matter, I think the Huffs and the Fosters should likewise be permitted to argue about the constitutionality of the floodplain ordinance itself, and that's at the core of this case, Your Honor. It's simply stated.
All right, thank you, Mr. Lewis.
Your Honor, in response to Mr. Richardson, the letter he's talking about, if you read language of the ordinance, the floodplain administrator can request one, it's not necessarily required. That was one of the things we did with Kevin C. prior to the May 22nd meeting, we supplied that. And if you want to throw out the new ordinance, let's go back to the old one, Your Honor. Jerry Evans had all the authority under that to issue our floodplain permit and everything. I mean, that's what we would be left with, is the old ordinance, if the new one's unconstitutional. I think we're all here today for the same substantive reason, and I just want to add that. If we do, as Mr. Stevens says, address and throw out the new ordinance, then the old ordinance will be still in effect.
3 seconds, Ron?
All right.
They were operating under the assumption of the old ordinance all the way until May of this year. Discovery, I had emails where they finally realized that there's a new ordinance. It's not a new ordinance, this is September 2011 ordinance. This is May 2012. So this shining example of following the rules, they didn't even know which rules to follow.
All right, thank you, Mr. Reed. Anybody have anything further on the intervener Huff's motion for summary judgment?